Welcome viewers to part 1 of our screencast on trust administration. My name is Richard Land. I'm an attorney and a member of the Danbury, Connecticut law firm known as Chipman Mizuko. In a separate screencast, we cover estate settlement from the appointment of an executor or administrator through the whole process of estate settlement, including the final count. Now it's time to talk about trust administration. This screencast was originally the last 3 parts of our estate settlement video, which is also available on YouTube. We thought it would be helpful to offer it as a standalone video devoted to trust administration. So here it is, edited for that purpose. Imagine that you've been named executor and trustee under your friend's will. After your friend passed away, you went through the process of asking the probate court to appoint you executor, and after you were appointed, you went through the process of settling the estate as described in our estate settlement video. Your job is finished. Your friend's will says that all his assets remaining after payment of debts, expenses, and taxes, and other legacies and bequests, all those remaining assets are to be distributed to a trust, and you're the trustee. Now, what does that mean? You need to know what a trustee's job is and the perils and risks that you, as trustee, will face during trust administration. And that's what we will be covering in this part 1 of our screencast. During this part, we will discuss what a trust is, what trust administration is, and the rules that apply to trust administration, typically found in the terms of the trust, and that's usually found in the last will and testament or in a trust agreement, and also rules that are found in our statutes, which cover trust relationships, and also in the common law. Those are court cases that have dealt with trust issues starting many hundreds of years ago. So, you're a trustee of a trust. To start, perhaps we should have a discussion of what a trust is. Although we talk about trusts as if they're actual things, or as if they are actually separate legal entities like a corporation, that's not really the case. Rather, a trust is a legally enforceable arrangement, more like a contract than a corporation. And when a trust is created, a trustee takes legal title to property, and he takes it to hold for the benefit of one or more beneficiaries. So title or ownership is typically divided between a trustee who has legal title and a beneficiary who has beneficial title or equitable title. And a trust is defined by a set of instructions. And as mentioned earlier, you typically find those instructions in a will or a trust agreement, and applied to those are the law as contained in statutes and in court cases. Trusts can be oral, but they're usually in writing. And there are many reasons for establishing trusts, but the reasons usually boil down to 3 distinct categories. People set up trusts to save taxes or to try to protect assets from certain risks such as creditors, claims, and bankruptcy, or to provide management of assets for someone who is either not interested in or not capable of managing the asset. A trust is created when the creator of the trust, usually called a grantor or a settlor, transfers property to a trustee, and the trustee takes possession of the property, agreeing to follow a set of instructions that the grantor of the trust gives to the trustee at the time. The instructions relate to how the trustee is supposed to manage the property for the benefit of others who are the beneficiaries of the trust. Perhaps it will be helpful if I give you a simple example of a very basic trust arrangement. Let's assume I want to establish a trust with some cash I have available. I can do that simply by writing the following to the trustee, giving him the cash, and getting him to agree to take the cash subject to my instructions. So here I say, I, the grantor, hereby transfer to George as trustee this bag of cash. George, I want you to pay the income that you earn when you invest the cash to John. And George, if as trustee you, in your discretion, decide it is appropriate to do so, I'll leave it up to you to decide whether to pay any of the principal to John. And at John's death, I want you to pay all the trust assets that then exist to Mary, Harry, and Sarah. The terms of a trust will usually go on for many more pages to describe how a trustee is selected if George is unable to act, and to describe tax and investment powers that the trustee can exercise, and quite a few other issues. But I think that this example should give you a basic understanding of what is at the core of the trustee relationship to the beneficiary and the assets of the trust. What is trust administration? Let's begin answering that question by looking at what a typical trustee should be doing. First, the trustee must make decisions relating to the distribution of trust income and principal, and the trustee must make decisions regarding property management and preservation. And the trustee usually is responsible for making investment decisions. The trustee must keep good records and account to the trust beneficiaries, and the trustee must communicate with the trust beneficiaries. The trustee often must satisfy certain disclosure and filing requirements and pay attention to tax reporting. This includes income tax returns at the federal and state level, and perhaps generation skipping taxes and estate taxes. And the trustee should be careful to document the decisions that he or she makes as trustee. And all this trust administration activity revolves around properly serving the interests of the beneficiaries. So let's talk about the trustee-beneficiary relationship. The trustee is a fiduciary, which means the person who is acting as a trustee occupies a position of special confidence, and that person will be held to the highest legal standards for all his actions. And the trustee is accountable to the beneficiaries of the trust and will be held liable for any breach of a duty owed to the beneficiaries when the breach causes damage to the beneficiary. We'll get into the duties in a moment. Although the trustee's job revolves around the interests of the beneficiaries, in performing his duties, the trustee will frequently enter into agreements with others. It's important for the trustee to keep in mind that he, not the trust, will be personally responsible for satisfying the terms of any contract he enters into with others. The trust and its beneficiaries receive the benefits of the contracts, but the trustee, not the trust, is liable for the trustee's breach of a contract. For example, if a trustee enters into an agreement for the purchase of property for the trust, and trust funds are used to pay a deposit which will not be refunded in the event of the trustee's breach, then upon the trustee's breach and loss of the deposit, the trustee will be liable for the deposit and must reimburse the trust. So a trustee should be careful when entering into contracts for the trust. And, of course, if a trustee's negligence in managing trust property causes damage to someone who's not a beneficiary, the trustee will be personally responsible to the damaged party, not the trust.
Now let's get into the trustee's duties. As I just mentioned, the trustee's relationship with the trust beneficiaries is defined by a list of duties that the trustee owes to the trust and to the beneficiaries. Let's quickly go through the list of duties, and as we do, keep in mind that if you're serving as a trustee, a fire-breathing litigator may be watching to pounce on any breach of a duty to hold you responsible for any loss resulting from the breach. As a trustee, in order to protect yourself, you will want to create a clear record that you were true to your duties and that there were no breaches. First and foremost is the duty of loyalty. That's the duty that prohibits self-dealing and prohibits you as a trustee from benefiting from the trust, except for reasonable compensation for your services. Examples of self-dealing include a trustee who borrows money from the trust, or who makes a loan of trust funds to a family member who is not a trust beneficiary, or a trustee who purchases a trust asset or sells a trust asset to a family member. These are classic conflict of interest situations, and trustees are supposed to be held to a very high standard, which requires them to avoid even the appearance of impropriety. The next duty is the duty to deal impartially with beneficiaries. This does not mean that a trustee cannot make judgment decisions regarding distributions to one beneficiary over another. In fact, the terms of the trust may require the trustee to make such decisions. But in doing so, the preferences of the grantor of the trust should be what guides the trustee, not the trustee's own personal preferences. In other words, the trustee should honor the grantor's preferences with detached professionalism. Let's quickly run through the remaining duties. There is the trustee's duty to take possession and control the trust property. There is a duty to keep the trust property separated from the trustee's property or the property of anyone else. This is the duty that prohibits commingling. As we prepare accountings for trusts, it still amazes me how frequently the duty not to commingle is breached. It always takes a lot of time to untangle the accounting mess that results from commingling. There's the duty to preserve and protect trust property. For example, the trustee needs to think about things like adequate insurance coverage, safe deposit boxes, and climate control for artwork. There's the duty to try to make trust property productive, to invest to generate income, or to find a tenant for a vacant apartment, and the duty to pay income to the income beneficiaries of the trust. Keep in mind that when the grantor of a trust creates the trust, the grantor can always, within the terms of the trust, change how such duties may be applied. For example, although the trustee typically has the duty to distribute income, the terms of the trust may direct the trustee to do otherwise, and the trustee has a duty to follow the terms of the trust. The trustee has a duty to keep good accounts and to share information with beneficiaries of the trust. And the trustee has the duty to exercise reasonable care and skill. For most matters, except for investments, this means the trustee must conduct himself with the same skill and care that someone with ordinary prudence would exercise with respect to his or her own property. But there's a special rule for investments. With respect to investments, the trustee must satisfy the prudent investor rule under the Connecticut Uniform Prudent Investor Act, which we will talk about later. And, except for investment activities, there is a duty not to delegate the responsibilities of the trustee. The trustee has a duty to exercise personal judgment with respect to the administration of the trust. But, once again, for investments, there's an exception which actually encourages the trustee to delegate certain investment and management functions when appropriate. And how that works is also spelled out in the Connecticut Uniform Prudent Investor Act, which we will talk about later. There's a duty to enforce claims that the trust might have against others. For example, if one of the assets of the trust is a promissory note signed by the grantor's son, and the son defaults, it's the trustee's duty to enforce the note, even though that might be a very uncomfortable thing for the trustee to do. And the trustee also has a duty to defend the trust when someone is making a claim against the trust assets. The point of going through all these duties that we just reviewed is to give you some idea of the special status a trustee has and the trustee's special concerns. If the trustee does not understand his special concerns, duties, and responsibilities, and act accordingly, the trustee will expose himself to significant liability. As attorneys, our job is to help the trustee satisfy his duties and avoid exposure to personal liability.
That's the end of Part 1 of this screencast. In Part 2, we will more fully discuss trust accounting, investing trust assets under the Connecticut Uniform Prudent Investor Act, common challenges trustees deal with, and trustee compensation.